Thank you all. I'm so happy to see so many in attendance. We will have our oral argument today, as we would in the State House, and we are being webcast. And then after the argument is over, we will take questions from the students if there's any kind of question except about the case, all right? Because as soon as we're done, it'll be under advisement. So we have Mr. Skis, is that correct?
Good afternoon, Your Honor.
What is it?
Sorry, good afternoon, Your Honor.
Good afternoon, and you have reserved 5 minutes for rebuttal.
That's correct.
Is that correct? And Mr. Mullinex? Thank you. And Crystal Rowe? Will you be arguing, Ms. Rowe? No, Mr. Mullinex, thank you. All right, you may begin.
May it please the court, counsel. My name is Ed Skeets, and I represent the appellant, Sharon Handy. This is a premises liability and personal injury case. In order to resolve summary judgment at the trial court level, the trial court first had to determine the legal status of my client at the time of her injuries on property owned by PC Properties LLC.
How much are you and your client affected by the Trial Rule 56 deadline issue?
Pardon me?
The deadline issue with regard to submission of evidence with regard to the motion?
Well, and Your Honor, in this case, there was an agreement between the parties to allow my client extended time to respond.
But the court, no one ever applied to the trial court itself and received a ruling. Is that correct?
That is correct, Your Honor. And in this case, there's been no cross appeal on that issue. That evidence that we presented was certainly allowed by the trial court, and the trial court accepted our evidence and made its decision based on the evidence that was submitted by the appellant.
But does the judge have the authority to extend the deadline on a 56?
In this case, Your Honor, the court certainly did, and
But not by the language of the trial rule,
this.
would you say?
Not by the pure language of the rule, but in this case, obviously, the court did allow it, and that's not an issue that's on appeal. There was no cross appeal filed on that issue.
It was raised by the Appellee. There was no reply to that argument in the Appellee's brief.
Well, and Your Honor, but we did submit the evidence, and the evidence was considered and ruled on at the trial court level in this case. In order to resolve summary judgment at the trial court level, the court had to first determine the status. Now, to determine the status, the Court of Appeals has consistently applied the invitation test adopted by the Burrell v. Meads at 569 Northeast 2nd, 637, an Indiana Supreme Court case from 1991. Our second point will be that we believe it was an error of law for the trial court.
What was that point?
Pardon me? Well,
Under Burrell v. Meads, what?
That the invitation test should be applied to determine the legal status of a visitor on property at the time of their injuries. Our second point, we believe there was an error of law committed by the trial court when it failed to apply the invitation test, because the court didn't look at the conduct and the activities, facts and circumstances related to the appellees in this case. They looked purely at the appellant's case, but the Burrell decision says you need to look at the conduct of the appellees. Our third point will be that if properly applied, the invitation test to the facts and circumstances of this case, a reasonable juror could conclude that an invitation had been extended to Sharon Handy at the time of her injuries. And our fourth point will be that sufficient evidence was presented by Sharon Handy that sufficient evidence of negligence had been presented by Sharon Handy, upon which a jury could determine that a duty owed to her had been breached by the appellees.
Well, the best that I think you could hope for would be to go to a business invitee status. Is that correct?
That's correct. And in
you
fact,
were found to be a trespasser. Is that right?
That's correct.
All right. Now, there's a middle ground, though. And can you help us with the licensee ground?
Well, in this case, obviously the business invitee is entitled to the highest duty under Indiana law, and that's the status that we believe our client had for very specific reasons. She was there at the time of her injuries shopping.
But the business was closed.
The business was closed at the time, and she was not shopping in a closed area of the business. There were 3 granite countertops leaned up against the wall outside of the store area on public display on the sidewalk.
So don't you think that under Burrell, the court did look at the appellee's conduct?
The court did not. Its
So
decision
they
is
looked at the fact that their countertops were lined up outside the building.
right, but the court didn't consider the fact that these countertop, in the testimony, that these countertops could have been placed in a secure area. There's a fenced-in, locked area where these countertops could have been displayed. They would have
Were the
received.
countertops visible from a public location?
Yes, Your Honor. They were in the very front of the store on
And
the
how
sidewalk
how
area.
far in distance was that from the sidewalk or the street or the nearest public throughway?
It is on what the owner of the business, Mr. David Stemler, testified he called the sidewalk, and my client called the sidewalk, literally right out in front. Now, this business, the setback of the storefront.
Somebody walking by on the public sidewalk would clearly see the countertops on
Yes.
the front of the store?
Yes, Your Honor.
Let me also ask, for a comparison between these items and any other items that would have been available for someone to look at, peruse, touch, move, before or after business hours? Were there other things? I mean, many of us have gone to a home improvement store, and at least in some, there's rental equipment out there, there's other equipment for purchase that's available to be perused. What was the situation at this store with regard to other merchandise?
And, Your Honor, I don't believe that we have any testimony establishing that other items were out in the front of the store at this time.
So we would need to proceed with an understanding that these may have been the only items that were out front.
Based on the testimony we have, Your Honor.
Right.
And your client had been to the store during business hours, how recently, and talked to a store representative about the possibility of purchasing such items?
Well, and that's one of the factors that makes this case very unique and interesting. She was there literally the day before to purchase items for the home that were on sale. So she was clearly a business invitee on July 10th, 2011.
Saturday, right?
Which is a Saturday, the day before her injury. She comes back, and at that time, there's uncontested testimony that she was invited to look at the granite countertops out in front of the store.
By a store representative on Saturday?
On Saturday.
But she couldn't have purchased them on Sunday.
She could not have purchased them on Sunday, and she testified that she did not know at the time that the store was closed on Sunday, but she came and her purpose was to inspect them, make sure they would even fit in the application that she intended, and she did just that.
Did
So-
the store representative make any representation to her that it would be okay to come back at a time when the store was closed and measure the granite tops or otherwise inspect them?
No, and conversely, nobody indicated, of course, that
Not
the
okay.
store would be closed or that it would not be okay. Nor, interestingly, on July 10th, nobody offered any assistance either, just indicated that they were out there, she could inspect them. Knowing that she was a slight woman of about 140 pounds, these granite countertops are very heavy. The owner of the store
Would have
testified.
been apparent to her as well.
Well, she's not in the business of working with granite countertops, and she really didn't know. Her testimony was that it was easy, relatively easy, because of the way they were leaning, to just move it a little bit.
Is there anything in the record indicating what the countertop weighed?
There is testimony that the countertops weighed from the 200 to 300 pound range.
And there were
Um,
two of them?
There was three.
Three. So when was she invited to come on the property?
Obviously, on July 10th,
Saturday.
Saturday.
But they didn't say come back Sunday and measure them.
Not expressly, and our argument, of course, falls within the body of law relating to implied invitations. As stated in cases going back as early as 1907, the Pittsburgh, Cincinnati, Chicago, and St. Louis versus Simmons case, the Indiana Supreme Court stated that if the owner goes beyond consent or acquiescence and by positive acts, just positive acts, or inducements entices others to come upon his property, he assumes the duty of exercising ordinary care.
Is this in any way analogous to the law in the area of attractive nuisance? And if so, how? If not, why not?
I would argue that it's really not an attractive nuisance. There's not an existing relationship between the injured party and the property owner. There's merely an item that somehow draws their attention. Here there is a existing business relationship. They knew she would be there on July 10th looking at these
I'm talking about the
items.
policy considerations that underlie the legal concept of attractive nuisance.
In this case, I would again argue there's not a close connection with attractive nuisance, because here there's an existing condition they could have warned her about. They had the opportunity to warn her about on July 10th, whereas with the attractive nuisance, you just sort of set something up and possibly somebody comes by. But here they had an existing duty to warn her about it on July 10th, and they shouldn't be absolved of liability simply because the same condition that exists on July 10th injured her on a day that was closed. They had the opportunity to correct that condition or warn her about that condition when she was there, but they clearly knew she would be inspecting those countertops.
The basis of your claim is not dependent upon some kind of failure to supervise a customer out there or anything like that, right?
No.
So your claim is not, according to your position, is not any way dependent upon, their negligence is not dependent upon whether the store's open or not.
Right. This is very analogous to a situation where a store owner has a sign up above his sidewalk, and he's known for months that it needs to be fixed. It's blowing in the breeze, and he's convinced that one day it's going to fall down. He needs to get around to doing something about it, and fails to act, and on Sunday when the store's closed, it falls down and hits somebody's head. He shouldn't be absolved of liability simply because
Well, that wouldn't be a business invitee.
that would not be.
No.
But still, the duty would
So
be
don't you
owed.
need permission to come onto the property on a Sunday when the store is closed as a business invitee?
And we find it under the implied invitation that's here. This is different
But
than,
wouldn't that implied invitation mean come back when we're open?
we would argue that it certainly would if you were talking about items that were stored in a secured area. But if you're going to leave items out there for public display on a 24/7 basis, that implied invitation seems to suggest that you can come at any time. There's no warnings, there was no trespassing, there was no barricades, definitely no restraints or anything present on these items to say, hey, you can't look at these when the store's closed. This was clearly a situation where these were left on public display for the sole purpose. As Mr. Stemler testified, there was nowhere in the store that they would get the visual effect that they would from outside the store. They would not be seen by most customers that walk in and out of the store. He said that that testimony can be found on page 60 to 61 of our appendix. In addition, there's testimony where he indicated that a drive-through area that is secure at night could have stored these materials behind this fence, but not as many customers would have seen them. Their sole purpose for putting these out there in the front and choosing not to put them in a security area so the public could see them.
How do you answer the Appellee's argument that if there was a danger from messing around with these countertops that were stacked there, that it was open and obvious to your client?
My client testified that she had no idea how much these items weighed. She never worked with them before. She's an attorney. She's not a building materials expert and doesn't deal with granite countertops. She merely...
And it's your position it requires expert testimony or expert background to know that a 300-pound piece of granite that's leaning against the side of a building may tip if you stand it up or mess with it, that it might fall over, particularly if you're a small person and not physically capable of handling a 300-pound object?
Well, we're arguing that it's obviously not an open and obvious hazard because it wasn't open and obvious to Miss Handy, and she was able to move that first countertop very easily. Yet we had testimony from Mr. Stemler where he said they use at least 2 employees to move each one of these single granite countertops for their safety, but that information was not
That doesn't mean the danger's
available.
not obvious. It just means she wasn't injured the first time. I mean, that's kind of like playing Russian roulette with a gun. If you spin it and you get an empty chamber, you didn't get hurt, but that certainly doesn't mean that that's not a dangerous operation to engage in, right?
Right, and we would argue, though, that that was an issue for the jury to decide in this case, and they were denied that opportunity, obviously, because of the summary judgment.
What are we to make of your client's legal training? In other words, should she have known better?
She's a corporate transactional lawyer, Your Honor.
She knows nothing, right?
Well, you're saying that it's an issue for the jury because it's a question of proximate cause, not a question of duty, right?
Well, the question of duty, again, goes to, I believe, their duty to warn or make these items safe. Now, there was testimony from Ms. Handy that is uncontested that a business like Lowe's or Home Depot restrains these items.
But if she's a licensee, they don't have to protect her against obvious dangers, right?
They,
I mean, that's one of the differences between the
Right.
duty owed to a
Right.
licensee and a business invitee, right?
right, and here we're arguing, obviously, she was a business invitee because
But
under,
if we find her to be a licensee, then whether or not this is an open and obvious danger may preclude the viability of your claim, would it not?
potentially, but I don't see how we could find her to be a licensee in this case when she's shopping for goods that are for sale at that business.
What's the difference in Indiana between the definition of a licensee and a business invitee?
The business invitee is somebody who, if you'll bear with me just a second, and I apologize. I may have to I realize that I'm about out of time. I may have to come back to that and I do. I apologize.
Thank you very much.
Thank you.
Good afternoon. I'm Richard Molyneux, and I represent PC Building Materials, Inc., PC Properties LLC, and David and Karen Stemler.
Mr. Milano, can you answer the question that I just asked Mr. Skees? What's the legal difference in definition in Indiana between a licensee and a business invitee?
Okay, a licensee is someone that goes on the premises, and the landowner has a duty to refrain from willfully or wantonly injuring that individual or acting in such a manner to increase their peril and to warn of latent defects on the property.
And your position is this is not a latent defect, right?
Correct.
Okay. And a business invitee?
Business invitee is, and I think Judge Shepard did it very nicely, and Burrell said that the business invitee is an individual who comes upon the land by invitation to enter or remain on land for purposes directly or indirectly connected with business dealings and with the possessor of the land. And what they say with regard to that individual in that classification is that they have a responsibility for physical harm caused to the invitees by a condition on the land, but only if he knows by the exercise of reasonable care they would discover the condition and should realize it involves an unreasonable risk of harm to the invitee and should expect that the invitee will not discover or appreciate the danger and protect
Okay,
themselves.
I think you gave me the definition of the duty owed to a
Right.
licensee. What's the difference in terms of defining whether an individual is a licensee or a business invitee? You touched on that a little bit, but could you address
Sure.
that?
Let me try to do it a little bit better in my words, and they probably won't be as eloquent as Chief Justice Shepard's, but if it's a business invitee, there's a duty to exercise.
No, not the duty. How do you define?
It's a business invitee is someone who comes on the premises of a business
Right.
by invitation,
Okay, and a licensee differs from a business invitee in what respect?
because there is no invitation for a licensee to come onto the property. The licensee is there either with permission or the sufferance of the landowner, i.e. the landowner knows that these individuals are going to come on the property, but they don't do anything to prevent them from doing that. They don't put up no trespassing signs. They don't do anything, put up fences or barricades.
So they're there lawfully, but they're not explicitly or implicitly invited onto the property. Is that a fair definition of the difference between a licensee and a business invitee?
It is, and I think they're there with, lawfully is maybe a stronger word, but they're there with a, it's not a right to be there either, but they're there.
Do you agree with the trial court that the lady in this case was a trespasser?
I do.
And why is that?
Because in this particular case, and I think it's very important that we look at, in applying the Burrell case, we look at the invitation, and we look at every case that's addressed this, looks at what was the status of the individual when they came onto the property. It doesn't matter what happened on any day before, unless there's an express invitation, what was going on that Sunday, July the 11th, 2010, when she entered the property. And she didn't know whether or not the store was open, she's testified, when she started her journey, but when she got there, it was very clear to her that the store was not open.
Go ahead. But let me interrupt to ask, under your analysis, it seems then, anyone who goes onto a car dealership's lot on Sunday is a trespasser.
Well, I think that's a little bit different, though.
How so?
Because when you have a situation, well, in Indiana, obviously they're closed by law on Sundays, but they have, in each one of the cars, there'll be a price tag painted on the front. There'll be advertising.
There was just an item for sale that's clearly for sale, and she had found that these granite slabs were clearly for sale.
Right, and that the store was closed on Sunday, and that there was no one there, there was no information there, nothing there for her to do when she came onto the property. Now, the reality of the situation with regard to the trial court, whether she was a trespasser or a licensee in the overall analysis is inconsequential.
Do you think you win either way?
We win either way, yes, sir.
Why shouldn't a jury be entitled to make that decision, though?
Which decision?
The decision as to what characteristics the client had going onto the property that Sunday after the Saturday with granite slabs that are clearly for sale, leaned up against the side of the building.
Well, I guess I should take issue, and I want to answer your question. Well, let me just, if I may, because I think there has been some misinformation given to the court. The sidewalk they refer to was at the front of the store. Mm-hmm. And basically, at the time this happened, there was an indentation in the store. There were two outer walls, and then there were two solid walls that went back to the front of the store, which was recessed. And there was glass on the front of the store, and there was a doorway as you faced the store to the right. These
Were the items visible from a public place?
They were not. That's the point. There was in front of the store a large parking lot. My estimate would be, and it's not in the record, but my estimate would be, between 100 and 200 feet from the front of the store to the street. There's no sidewalk there.
There wasn't any impediment to pulling into the parking lot, right?
There's no impediment to pull.
There's no way this lady could have known the store was closed until she walked all the way to the front door and saw the sign that listed the hours.
Well,
She could have checked somehow ahead of time, but somebody walking upon the scene or driving upon the scene, seeing the store, pull in the parking lot, totally innocent, could walk all the way up to the front door before they would know that the store was not open on Sunday, correct?
They could do that. She testified that she knew when she got there. Now, whether when she got there meant pulling in the parking lot or not.
But there was no indicia displayed to the public other than the hours on the front door, right?
Right. And the lights were off, and there were no cars in the parking lot, and none of the things you'd expect to see when the store was open, because the parking lot's right there in front.
Well, couldn't you consider the countertops an invitation to come onto the property?
No.
To check them out?
In making that determination, before you answer that,
Sure.
Isn't one of the criteria whether they're put there for a business purpose or not? I mean, the business generally, not necessarily this, but businesses generally display wares to attract customers. That's a business purpose, right?
Well,
Put them in the front window, they put them on the sidewalk out front.
let me just say, I disagree with the idea that council suggested that these were on public display. These countertops.
Okay, but in a general sense,
Well,
that businesses display wares for sale in the front of their store to attract customers, right?
they could do that. They could. In this particular case, though, I think it's important to understand that these countertops, they are not an item they're carried by the store for sale in that condition, in that state. I mean, we're talking about countertops that go in kitchens. They're large pieces of granite stone that are cut specifically for kitchens.
Then what were they doing outside the front door?
If I may, what happens is when a customer wants to order them, they go in and there are samples that are maybe 3 inches, 4 inches square, and a customer orders them from that. And with that, once they make the order, they contract with a third party to go measure the kitchen, to know exactly what the dimensions are, exactly where the sink's going to be.
So
and
they're there
cut
for
'em.
display, they're there for display, not sale?
Well, They're not really there for display because they're not in the business of selling those things like that, those countertops. What they're in the business of doing is when they are returned, either because a customer rejects them, because they're miscut, they return them to the store and they take them back. There's no place in the store for them because they don't.
Could they have seen the countertops from the parking lot? You talked about them being in
Well,
a recess.
I guess anything's possible, but what I will tell you is when Miss Handy went to the store on Saturday, when she's walking into the doors to the right, she doesn't see them, and they're there to her left. She doesn't see them.
Did she test, is that in the record?
Yeah, she doesn't see them. She doesn't know about them until the lady inside the store says, "Oh, on your way out, take a look if you're interested in kitchen countertops." That's the extent of that exchange.
Okay, so that goes back, is that an invitation then?
That was an invitation on Saturday, okay? And she did, she took it and she looked. But then the important thing and the most critical thing in this analysis is she left. She left the property. Her status as an invitee that day ended. And there's no doubt that she was there was an implied invitation when the store was open for her to come in and do nothing but shop. She can look
So
around.
if they had fallen on her on Saturday, she'd be an invitee, and we wouldn't be here today because you had settled the case a long time ago.
We would not have, because under 343 and 343A, these were opened, these were big pieces of granite. They did not fall on her. She pulled them over.
Is that an issue for the jury to decide?
Pardon?
Is that an issue for the jury to decide?
I don't see how it could be, Your Honor. These are,
Was it an issue of proximate cause or an issue of duty? One's decided generally by the court and the
Right.
other generally by the jury, right?
not, except in premises liability cases, when you're looking at a standard of willful or wanton misconduct and all they've pled is negligence, the courts can make that decision. It's not only on duty, but it's a matter that's been accepted for summary judgment to determine that there's no breach of that duty as a matter of law, when there's no allegation of willful or wanton misconduct, just as we have in this case.
So it's your position that even if we were to determine that she was a business invitee, you win as a matter of law and summary judgment?
I believe we do, but she would have to be determined as a business invitee on Saturday because her
No.
status.
I'm talking about if we were to decide
On-
that she was a business invitee on Sunday,
Yes,
that on the basis of your argument regarding the open and obvious, you would still prevail at the summary judgment stage of this proceeding. Is that your position, sir?
I believe that, Your Honor, yes. And I also believe that it must be as a result of a condition on the land and or an activity that we were engaged in. The stone granite tops were leaned against the building.
Who leaned them there?
Well, it's not been established. It could have been the subcontractor or the third party that put did
It's a condition on your property that your people are aware of, right?
Well, it's two or three pieces of stone that were leaned up against the front side of the entrance.
But
So
your
people
people
going
were-
in and out of the store could see, not for people driving up and down the street to see,
Right.
not for people, this is a standalone store.
Right,
It's
but
not,
your people were aware of it.
our people were aware they were there.
Right.
And I'm a little bit intrigued because, as I indicated before, anyone who's walked in and out of a home improvement store, a large big box, as opposed to perhaps a smaller store, has seen these same things up against the side by the entrance. But you're telling me that in your client's instance, these are returns that have been delivered there by a third-party contractor for your client to deal with as it needs to regarding returns of granite.
Right, these were rejected or defects. They don't happen that often. They don't have room in the store to put them, and they put them there because
Well-
people going in and out of the store can see them. They're not marked for sale.
Right.
They're for people to see, and if they're interested, the odds of them fitting another store or another kitchen are pretty small.
These have actually been cut.
Yes,
Okay, and so, but these are in a condition, in a location that you know that customers are going to walk aside, and you didn't put them there just so that they would go out with the next trash. Otherwise, they would have been at the back alongside the dumpster, right?
No question that we put them there, and the idea was somebody might need them. Generally, it's another contractor, but somebody might get them and, pay something for them to cover some of the cost and take them.
So the key is, you did put them out there with the idea that a retail customer might become interested in them.
That's possible.
All right.
Yes.
Help us with the state of the case law with regard to transferring or not the clear business invitation of Saturday to a return visit on Sunday.
Okay. I think that the law is pretty clear. As soon as she left the property on Saturday, her status ended. She had no status at that time.
What's her status when she pulls into the parking lot on Sunday?
Well, my understanding was she already knew when she pulled in the parking lot they were closed and decided to go ahead anyhow.
So when she
In
pulls in
that
the
case,
parking lot on Sunday, what's your position?
I say she would be a trespasser if that's the case. If she didn't realize until she got to the store, then she could well be a licensee. But
Up until
again,
the time she sees that the store is closed.
right.
And then does she immediately become a trespasser? Or is she given the opportunity to vacate the premises? At what point in time does her status change?
I think it really doesn't matter in that case between a licensee and a trespasser because it's a very similar duty, and in the circumstances of this case, it's pretty much the same because this is not a latent situation. I mean, they're there. They're obvious that they're there.
If you don't want to establish people, if you wish, I should say, in the affirmative, if you wish to establish people as trespassers, why are there not gates on the parking lot that are locked?
That's a good point, Your Honor. I'm not saying that I wish to establish them or that my client wishes to establish them as trespassers. I'm trying to just do an analysis.
Trial court did, though.
The trial court
Trial
did.
court made that finding.
The trial court made that
Having
finding.
made that finding, which is arguably erroneous as to her status, you're arguing it wouldn't make any difference if it was a licensee. But that's not what the trial court held. The trial court didn't find, as a matter of law, that the evidence clearly led only to one result if her status were a licensee, right?
Right. The trial court
There's a
found that
difficulty in terms of trying to, if we find her not to be a trespasser, then you're asking us to make the jump that the trial court would have then gone on to find that as a matter of law, there was no issue of material fact that would preclude the possibility of a jury ever hearing the question on her status as a licensee, right?
right, she would be a licensee.
That's a big jump, isn't it?
No, I don't
Based
think
on
it's
these findings?
I don't think it's a big jump at all, Your Honor.
Why not?
Because the big jump would be to get her to be a business invitee on Sunday, because there was no invitation. An invitation,
But the trial court didn't make a finding that if her status were that of a licensee, that there would be no material issue of fact under the standard that's applied to a licensee, right?
the court determined she was a trespasser, so they didn't address the issue of licensee.
So are we to
Right.
presume that if she was a licensee, the trial court would have reached the same result on this record?
Yes. That's what I believe, and I believe this court will too. It's the same.
I'd like to step back just a moment to ask you a question that I asked your opposing counsel, and that is, what are we to make of the agreed extension of time for the submission of evidence in opposition to the motion for summary judgment?
Well, the agreement was in the form of, I will not oppose.
Right. No, and I
Will
understand.
not object to.
And I want to affirmatively say to you that I applaud the collegiality involved.
Right.
But I also have to apply the law as it is written in the state of Indiana, as it's been developed in the case law. And my understanding is that no matter what you folks agreed to with regard to a Trial Rule 56 evidentiary submission, it takes a trial court's involvement with regard to that in order to make it effective.
Did you object to that at the trial court level, to the trial court's consideration of those items?
We did not, we did not object to the response to the summary judgment and the evidence he designated initially. Then, much later.
Even if that were filed late, then that's waived, right?
Well, no, I don't believe so. Not under these cases. I don't believe, especially under Mitchell, which I think is the most recent one to address it. where they, at page 972, they say it's now firmly entrenched as an article of faith in Indiana law. This bright line rule provides clarity and certainty to an area of the law that for too long lacked both. So, I mean, they basically say that under Rule 56, if in fact you do not file your response and your supporting documents within 30 days or 33 days.
But that's not the same issue
Well-
as whether or not your claim is waived for failing to object to it at the trial level, right?
Well, I was going to try to get to that, if I may. There's three ways that it can be addressed. They can either be responded to, as I understand the cases, within the time period. You can ask for more time under 56I, and the court has to rule on that and it'll either grant it or deny it. Or the court or the individual can by affidavit say under 56F, we need more time to do some more discovery before we can respond. One of those three things has to happen within that time, and as I understand the cases, the court has no authority, the trial judge has no authority to do anything even beyond that. If it's beyond the 30 days or 33 days, the trial judge doesn't have authority to extend the time or accept it late or even consider it.
Any further questions? Thank you, Mr. Mullinex. Mullineaux, sorry.
That's all right.
Your Honors, thank you. In rebuttal, I would say that as it related to the difference between the status as an invitee and a licensee, I believe Mr. Molyneux covered that, although it was something I promised I would get back to. I think we're good there. It's important to note that the overriding theme, obviously, of their brief is that this invitation, as it will, expired at the close of business on Saturday, yet there is no case law cited by appellees or stated in Indiana that specifically states that this invitation expires.
Is there any case law on the other side that
There-
says that, invitations can extend over a long period of time?
Well, our closest case, and is a recent decision of this court in Huffman versus Dexter Axle Company, a 2013 case by this court. Appellee's argument was specifically raised in that case. They said, we were closed for business at the time of these injuries, and the court wholesale rejected that argument, and it came down to issues of control. They stated that the fact that Dexter left its property open, almost like leaving the countertops out in front, when no Dexter employee would be on the premises as further evidence, Dexter did not ultimately release control. So this Court of Appeals has already rejected this argument that sort of that automatically business closed, invitation expires.
What would have happened if we'd had locked gates?
In this case, obviously, there would have been no injuries. There could have been numerous precautions taken to prevent.
Oh, I'm talking about locked gates to the parking lot, and your client stepped over or around and walked up.
Then
Totally different case, and we wouldn't be here because you wouldn't even have brought it?
I would not be representing somebody who had crossed. That's more analogous to the cases that appellees have cited here, where there's a clear indication my client's presence is would have been unwanted in that situation. There's nothing like that here, which brings me back to the sort of the questions about what testimony was in the record. Mr. Molyneux had indicated that you couldn't see these items from the street. Mr. Stemler, the owner of both PC Building Materials, Inc. and PC Properties LLC, stated in response to my question, where I stated, I may have asked you this, but again, I just want to make sure, where these countertops are located, as they are depicted in Exhibits 2, 3, and 4, I was showing them pictures. There isn't a fence around them. You know, the public's not barricaded from seeing these, correct? And he said, no. In fact, they're displayed so the public can see them, correct? Yes. And then I went on to ask him about, well, why? I mean, they're placed out there to maximize the visual impact of them. So this sort of testimony that they're shielded from public view is in direct contradiction of the record provided by Mr. Stemler, the owner of the businesses here. I want to build on Judge Mathias's your car analogy. The car dealership. I'd argue there's even a higher duty in this case when in your average car dealership Sunday afternoon scenario, you have no idea. There's no existing relationship with a person who could potentially walk on the property, although there should still be obviously a duty to warn of dangerous conditions. In my case, there was already a relationship, and they had already invited my client to look at these granite countertops. They didn't take them away and put them behind the store or lock them up. They left them out there for not only my client, but for anybody to see. Public display. It was exactly how Mr. Stemler had agreed. Again, there's no case law that this invitation expired on Saturday. I want to talk in greater detail about this Huffman versus Dexter Axtell's decision that was recent.
But in Huffman, didn't the truck drivers have permission to be on the property to pick up their loads?
They did, Your Honor, but the argument was made, again, that the business was closed and therefore no duty. And here, the argument is being made that the business was closed and therefore no duty, but that argument's been rejected by Huffman. The analogy we would make to Huffman in our case is that there's an invitation. In Huffman, it's express. In our case, it's implied. The items are left out there. But an important part of the Huffman decision is the determination of the duty owed may turn on factual issues that must be resolved by a trier of fact, and that's on page 953. We've spent a great deal of time talking about the actual facts of this case. That was argued at summary judgment and presented at the hearing on summary judgment, yet all of those facts were resolved in favor of the appellees, and that's why we're here today. I realize I've run out of time.
Thanks, sir.
Thank you.